We'll hear argument in 22313, Pecos County Appraisal District and Kinder Morgan Production versus the Iraan-Sheffield Independent School District from Pecos County and the 8th Court of Appeals District. Kinder Morgan is represented by Mr. Heidler, the Appraisal District by Mr. Evans, and the Respondent School District by Mr. Lemon. Justice Boyd cannot be present this morning, but expects to participate in the decision of the case. Mr. Heidler, we'll begin with you.
Thank you, Your Honor, and may it please the court. Tax Code Section 6.30 does not authorize the taxing unit's contingent fee contract with Mr. Lemon because that provision authorizes contingent fee contracts for only one purpose: to enforce the collection of taxes that are delinquent. And here, the taxing unit's contingent fee contract has nothing to do with tax collection, and the taxes that the taxing unit is trying to have imposed on Kinder Morgan in the first instance are not delinquent taxes under the tax code. Let me start by distinguishing tax collection, which is what Section 6.30 addresses, from tax equalization, which is what Mr. Lemon is doing on behalf of the taxing unit. Tab 2 of my oral argument exhibits is a chart prepared by the Texas Comptroller, which outlines the 4 phases of property taxation in Texas. The first phase is the appraisal phase. This is where appraisal districts, like the Pecos County Appraisal District, appraise all the real property in the district for taxation purposes. The second phase is the equalization phase. This is where the taxing units, like the respondent, can go into appraisal review boards and challenge the appraisal district's appraisals within the limitations imposed by Section 4103 of the tax code. Importantly, in this case, the taxing unit has engaged Mr. Lemon to work here in the equalization phase by bringing appraisal challenges.
Heidler, I thought Mr. Lemon's argument was that the equalization phase is long past for these particular parcels because they were assessed, and he says that they were assessed as a result of fraud, and so therefore it should be considered as if there was that the property was entirely omitted, which then brings us to the issue of whether 6.30 applies as a result of that sort of omission. But hasn't the equalization phase already passed?
So, Your Honor, after the equalization phase, the appraisal is certified to the tax assessor for the assessor phase. So we're still in the equalization. Right. We haven't gone.
And that's passed too, right? For all the tax years we're talking about.
For these appraisals, that the original appraisals, yes, but this is a taxing unit challenge to an appraisal before an appraisal review board and an appeal. So in a case like this one, you have to look at Chapter 42 of the tax code. 4241 tells you if they win in this case, what they get is a new appraisal. The jurisdiction then reverts back to the chief appraiser to certify that new appraisal for the tax assessor. And then under 4242B, the tax assessor takes the new certified appraisal and uses it to calculate the amount of additional taxes that are owed. That's the language of the statute. And then to mail a supplemental tax bill to Kinder Morgan. That's what would happen here. And 4242B is clear that the additional taxes on the supplemental tax bill would not be due until receipt of the supplemental tax bill, and the delinquency date for those taxes would run from the date of the mailing of the supplemental tax bill. So in a case like this, where that supplemental tax bill has never been created, those additional taxes have never been imposed, we can't be in the collections phase yet. And that's what Section 6.30 addresses. It's limited to tax collection, which is the fourth and the final phase of property taxation. Collection takes place after the first 2 phases, where property appraisal values are established and challenged and ultimately certified as final. After the third phase, that's when.
But why can't what we said in White is that if omitted property is assessed, then it can be assessed for then the taxes can be assessed for prior years as well, and that a contract to find that property and get it assessed not only for the current year, but for past years is a contract in connection with the collection of delinquent taxes.
Yes, Your Honor. So White versus McGill in 1938 was construing the taxation statutes that existed at that time. And there are really
which
important...
seem to be pretty much the same language about the collection of delinquent taxes that we have in 6.30.
Well, Your Honor, there's a difference in the language, and I think it's a critical one, especially when viewed in light of the legislative policies behind the modern tax code of 1979. So the difference I'd point out is White versus McGill was construing Article 7335A. That article referred sort of loosely to contracts, quote, in connection with the collection of delinquent taxes. In contrast, Section 6.30 refers much more specifically to contracts, quote, to enforce the collection of delinquent taxes. Those words, to enforce, are a reference to an enforcement suit, a delinquent tax suit that a taxing unit would bring against a taxpayer to collect delinquent taxes. Under the modern tax code, that kind of a lawsuit can only be brought once the taxes are in fact delinquent. It would make no sense to allow a taxing unit to bring a delinquent tax suit against a taxpayer the day after the bill is mailed, or even in this case, before any tax bill reflecting these hypothetical additional taxes has been mailed. In addition, the modern tax code of 1979 contains important taxpayer protections that weren't in the statutes when White versus McGill was decided. I point the court to Section 1.15 of the modern tax code. That's the provision that says the taxing units, which have a financial interest in maximizing property appraisal values, cannot hire appraisers for taxation purposes. In addition, under 2501B, the neutral appraisal districts are authorized to hire appraisers, but that statute makes clear that the compensation of the appraiser cannot be contingent on the amount of the appraisal. So the purpose of both of these provisions is clear: to ensure that property appraisals in Texas are not influenced by any profit motive. That's very different from the taxation statutes in 1938. But the Court of Appeals here interpreted Section 6.30 to allow a financially interested taxing unit to hire a financially interested contingent fee attorney to try to ratchet up property appraisal values of especially valuable real property like these oil and gas interests. And
so what are the options for a financially constrained taxing unit in one of the poorest counties in the state to be able to adequately investigate these issues?
Well, Your Honor, let me be clear. They're not claiming they've been defrauded. Okay, they're claiming that the appraisal district has been defrauded.
I think Mr. Lemon may disagree with you about that.
Well, if you read his petition, he's claiming that we gave false information to the appraisal district, resulting in an appraisal that is too low. So the party that was defrauded was not, we didn't make any representation to his client, the taxing unit. The representations were allegedly made to the appraisal district. So if the appraisal district has been defrauded, it can bring a lawsuit. It can protect its own rights. We've seen that happen in the Beck and Maston case, for example.
Does it have the resources to do that? And if not, what are its options?
Well, Your Honor, the appraisal district is a co-petitioner here. It's a party to this lawsuit. If it can participate in this lawsuit, it should have the resources to pursue tax fraud. And in this case, we know the decision is not based on resources. This taxing unit did what should have been done initially. They came to the appraisal district and said, hey, we want you to look at this. The appraisal district did an investigation, looked at the communications between Kinder Morgan and the appraisal district and said, no, there has not been any fraud here. And now, instead of pursuing a claim against Kinder Morgan for fraud, the appraisal district is here in court defending its appraisals against this challenge. So that's what should happen. If the taxing unit thinks it's been defraud, that there's been fraud, it can go to the appraisal district and point it out. And we've seen in the jurisprudence that appraisal districts can pursue that. I would also point out that the education code does not authorize this engagement. The education code allows a school district to hire someone to assess or collect taxes, but going back to the comptroller's chart on tab 2, tax assessment and collection are the last two phases of taxation. Because Mr. Lemon is bringing appraisal challenges in the equalization phase rather than assessing or collecting taxes, the education code does not authorize this engagement. And because Texas law does not authorize this engagement, the trial court correctly granted the Rule 12 motion at the conclusion of the hearing. And having granted the motion, the trial court correctly struck the taxing unit's pleadings, thereby leaving the taxing unit with no pleading on file to support jurisdiction. So for these reasons, we think the trial court correctly granted the Rule 12 motion and correctly entered a judgment of dismissal. And we'd ask the court to reverse the Court of Appeals and to render judgment for the petitioners.
Any other questions? Thank you, Mr. Heidler. Mr. Evans, we'll hear from you.
Mr. Evans, please unmute and your microphone and video, please.
I'm sorry. I'll start over. The property tax code that was initially enacted in 1979 moved the property tax appraisal function from individual local governments to central appraisal districts. So instead of, say, a commissioner's court or a school board being in charge of appraisal, the property tax code put that in a central appraisal district with due process being provided by appraisal review boards. So to nail down the then new provisions in the property tax code relating to appraisal by a central appraisal district, in the code, the legislature also enacted Section 1.15, which prohibits taxing units from hiring their own appraisers. So in 1979, the legislature took the tax appraisal process, put that in the central appraisal district, and also codified the tax collections process. And that is in subsection E of the property tax code entitled Collections and Delinquency. That subchapter covers everything in collections from due dates to how delinquencies are handled. It covers the imposition of penalties and interest, and it outlines the process for filing delinquent tax cases in district court. As the exhibits that we have before the court reflect, there are several places in the tax code that specifically address when taxes become delinquent. For example, in section 31.02 of the code, taxes are due on receipt by the property owner and become delinquent by the statutorily prescribed delinquency date. In section 31.04 A-2 of the code, omitted property and the delinquent collections are addressed in that section. So, for example, the appraisal district finds omitted property. If a property owner happens to have property that's not on the appraisal roll, the appraisal district discovers it, puts it on the roll, then that owner's tax is not due for 180 days after the property is put on the appraisal roll.
What
and
about
after
the tax for prior years?
the tax for prior years would be included in the supplemental bill and would be due after that 180-day period.
And how does Willacy County, our decision in Willacy County, interface with that, pointing out that it doesn't turn on whether the taxpayer received or a bill was sent?
That language in the opinion basically says this: if you don't receive a tax bill, don't think you don't have to pay your taxes because you didn't receive a tax bill. The way I read it, it's like if I didn't receive a 1040 from IRS, that doesn't mean I don't have to pay income tax this year. Taxes are still due. I mean, if a property owner checks the tax roll from the tax assessor collector, that person's going to know that the taxes are going to be due. They're going to be payable.
Well,
But
3101 of the tax code says you don't even have to send a bill, right?
there are some cases that talk about due process and tax bills in terms of the delinquency date and penalties and interest. None of them come to mind at this point, but I think that if a person never receives a tax bill, that person is still liable for the taxes, maybe not penalty and interest, but I may not be 100% correct on that, but that's my understanding of how that works. So the omitted property argument, which is basically what the school district is asserting, that there's omitted property due to fraud. But even if a property owner were to find out that, or the appraisal district were to learn about omitted property, there are some procedures for the owner. Our position is that because the statutory scheme that is the property tax code, the term delinquent tax in the property tax code is not broadly defined and has not been broadly defined since its enactment, notwithstanding what the Court of Appeals said.
In the White decision, didn't this court say, well, we don't think that for purposes of what we have as 6.30, that we don't have to have a technical definition of delinquency? Which is to say, is it clear that by treating something as delinquent for purposes of the legal fiction of allowing the other side's argument to prevail, we don't necessarily mean that all the collateral consequences of what we would describe as delinquent in a very technical sense and other provisions of the term would necessarily apply, or would they? What's your position on that?
White versus McGill was pre-tax code, and the procedures in the tax code, for example, 6.30, specifically address who may represent a taxing unit for the collection of taxes and who may get paid under a contingency fee basis. That's specifically in 6.30. There was no 6.30, no tax code when White
there was
decided.
Article 7335A that contained the same words about collection of delinquent taxes, which is what we were interpreting in White. The provisions in 6.30, we respectfully submit, are more specific. Moreover, the code, like I said earlier, has just specific dates about when taxes become delinquent. And if you read the delinquency dates in connection with 6.30, it's clear that the collection of delinquent taxes and the ability for a law firm or a lawyer to receive contingency fees for the collection of delinquent taxes have to do with the delinquency dates. And
I guess I'm sorry for keeping you over, but I'm just wanting to know this one thing. When we said in White that we don't think that the legislature used the words delinquent taxes in a technical sense, why is it that we now must say that in the new and I get it, there's been codification and some substantial changes to our system, but why in this exact context, when the legislature continues to use those words, delinquent taxes, must we now treat them in a highly technical sense when before, in a very analogous circumstance, we said we didn't have to treat it in a technical sense.
Because in several places in the code, delinquency dates are set forth.
But isn't the whole point of White to say that we can untether it for purposes of just deciding whether or not someone has this authority? And I get also the point that it was coming at it from a very different perspective there. It was voiding a contract, but the argument could be made, what's good for the goose is good for the gander. So if we're not going to be very technical in the sense of being able to stop a contract, why would we have to not say, well, we don't have to be very technical in allowing one? That does not mean that we have to necessarily say that anything that's delinquent for purposes of 6.30 will necessarily have all the other consequences of delinquency, the extreme penalties and all that kind of stuff necessarily. It's just purely a question of authority. And that's and I won't ask again, but if you can help me on that one point, that's all I am asking.
Well, sure. But if you look, for example, at 3104A2, that is the process for recovering taxes on omitted property. And that is what the school district is asserting, that due to whatever happened, a claim happened, they are looking for omitted property. And the code specifically says when taxes on omitted property are due, when the delinquency date runs on omitted property. Basically, what the school district is asserting is that Kinder Morgan owes some taxes right now, that the taxes Kinder Morgan owes are due right now. And if that argument were to, carry further, then the delinquency dates wouldn't mean anything. The delinquency dates specifically say that if a person has omitted property, whether it's omitted by some kind of oversight or nefariously omitted, once that property is discovered by the appraisal district, the legislature has specifically provided for when those taxes are due and when the taxes become delinquent. The school district is trying to skip ahead a few steps and take the position that the taxes are delinquent now because there's omitted property that hasn't been discovered at this point. So our position simply is, if the code addresses how and when taxes on omitted property are paid, then that's what needs to be followed. And then if that's read in connection with 6.30, that is when a law firm that has a contract for contingency fees can do their collections. So everything ties together. The delinquency dates, 6.30, which takes us to our position that because of the statutory scheme in the tax code, delinquent tax, that term delinquent tax, is no longer broadly defined. It has not been broadly defined since its enactment. To define it more broadly basically opens the door to the targeting of businesses and individuals in the hopes that the ferret gets a huge payday for the very abuses that the White case referred to in its opinion, and in its reference to the very laws that these practices were intended to stop.
Your time has expired, Mr. Evans. Are there any other questions? Thank you.
Thank you.
We'll hear from the respondent.
Thank you, Mr. Chief Justice. May it please the court. The Texas Constitution provides that taxes will be paid on real property. The Constitution also provides that taxes should be equal and uniform. But when there is taxpayer fraud, we don't meet any of those requirements. This is a case about Kinder Morgan's taxpayer fraud. Before addressing the authority of the school to engage counsel to pursue the taxpayer fraud, I think it's important that the court look at what actually transpired before the trial court. An order of dismissal with prejudice was entered by the trial court. This court has long held that when death penalty sanctions or disqualifications are at issue, that exacting standards will be applied. And such was not the case during this hearing. The transcript reveals that the trial court simply misapplied the government code and its effective date in determining that the underlying contract was void. If we look at the findings of fact and the conclusions of law, we see that the trial court did exactly what this court said it could not do in Scurry County, Sackrock. And in fact, Kinder Morgan has admitted that in its briefing. Importantly, the pleadings of the school were never struck. It's not in the transcript, it's not in the order, it's not in the findings. There's not any reference whatsoever to striking the pleadings. Further, there was no opportunity to cure, and there was not even a request to see if there were other counsel available or if present counsel would continue to represent on a different basis. Further, at the hearing,
I wonder whether counsel, it's a little bit odd that this is coming up the way it is on this Rule 12 motion. And I mean, could you get another lawyer to represent if you were to get another lawyer to represent the school district on a more traditional basis, on an hourly basis, but then you had an agreement with the school district where the other parties are not privy to, that, you know, you're going to pay those hourly fees to that lawyer out of your contingent fee recovery. And that lawyer is the one filing the pleadings and not you, but you're involved, obviously. I mean, is that, would we be here if that were the arrangement?
I think that there are many different ways that representation could be provided. It could be on an hourly basis, except for this is a very poor school and it could not be afforded. It could be on a pro bono basis. It could be that a pro bono representation continues with a pursuit of quantum merit at the end. There are different ways that this could be addressed. I will go back to the fact that this is some of the poorest areas of our state and a poor school that cannot afford anything other than a contingency fee basis. But I also go to the fact that there is a total disconnect from my point of view between a issue as to compensation for a lawyer and a dismissal with prejudice of a school's rights that are explicitly shown in the tax code and that this court just recently reaffirmed the existence of. And at that hearing, the only evidence presented was that of the school, and the superintendent confirmed that indeed the school wanted to be represented. School wanted to be represented on a contingency fee basis, and the school authorized the pursuit of these unpaid taxes that resulted from Kinder Morgan's fraud. So just in the big scheme of things, it certainly seems that the punishment did not fit the crime, and the crime being that perhaps this contract wasn't technically authorized, although we profess that it was.
Well, I wonder, if the court says, what's your authority to represent the client? And you say, well, the client has engaged me. And the client says, yes, we have. Is the court, and then the court says, well, how are they paying you? Is that a question you have to answer?
See, I do not believe that it is appropriate in a Rule 12 to be getting into those issues by a defendant. That may be an issue that might come up at the end of the litigation. It could be, and I understand that obviously the client could be represented without any contract. So the contract is declared, if the contract were declared void, the representation is still there. There may not be any compensation, but the representation is there. And we go back to the fact that
But perhaps it's different perhaps when there's when it's the government, which can only act with authority granted by the legislature. I mean, perhaps that's the difference.
That is correct. And that goes to the fact that the section 6.30, we believe, provides the authority. And then you have the implicit authority under section 42.031 of the tax code, which was addressed in the Scurry County Sackrock case. So when you look at 6.30, I would ask the court to again focus on the fact that this is a claim for tax fraud. And as such, the fraudster should not be rewarded for having had their scheme be successful. And that's essentially what is being argued by the petitioners in this case. If you look at the language of the statute, delinquent taxes, it's very clear. It means that it was overdue in payment. That's legally what it means. This court addressed it in White and said it should be broadly interpreted. And if you then combine that with what this court said in Itasca County, which holds that the taxpayer owes a continuing obligation to pay on its property, then it's consistent to say that, yes, these are delinquent taxes. They received the bills. The amount that is shown on the bill, however, is not accurate because of the fraud. But I think the Willacy County case really kind of brings it home as to why, when you're dealing with a claim of taxpayer fraud, it should be a separate issue, because the fraud skews the entire taxing code system. In Willacy, the court did say that it's immaterial whether a bill has been sent or not, that delinquency is dependent essentially on having owned the property. This court also reaffirmed the existence of what we call the Beck issue, where if fraud is shown, then the court will presume or make a finding that these properties were omitted. But that doesn't happen until the fraud is actually shown.
Is your claim that they were omitted or that they were undervalued?
Well, what my understanding of the case law is they were undervalued because of the tax fraud. They are not omitted in the normal sense of the word omitted until that finding of fraud exists and the court has a legal fiction that says, okay, you engaged in fraud, so therefore we're going to treat this as if you did not file anything whatsoever. And
so going back to the to the question about the procedure of the motion to show authority, would you say that's premature in some sense, because we have to know whether fraud occurred and thus whether the property was omitted before we know whether it falls within 6.30?
I believe that it is premature, but I also think that it doesn't actually occur until the case has been resolved, in that these properties do not become omitted until the fraud is shown. But at that point, it is a legal fiction solely for the fraudulent conduct to be addressed.
If it turns out that they were omitted, that they were undervalued, but it was not because of fraud, does that mean that there was no authority to have exercised 6.30 contractual rights from the beginning? Or would it be possible, even if it's not fraud, but they were in fact undervalued, to proceed to deem everything? Because you're saying it, we won't know that until the very end of the proceedings, to nonetheless say that everything was okay and we can now regard it as undervalued and you get your fee and all the rest of it.
Well, I think the case law is very clear that fraud has to be shown for there to be any adjustment to the property values. This is not a situation.
Because otherwise you can't challenge the amount of the appraisal.
That is correct. And so therefore,
Undervalue, there is no kind of undervaluing remedy for taxing authorities other than fraudulently undervalued.
well, specifically for taxing units, that is the case. As for the appraisal district, there may be other rules. I'm not sure. I mean, they can, obviously the appraisal district can go back 5 years and reappraise under 2521. But for a taxing unit, the current state of the law is that fraud must be shown in order to get this legal fiction that there was the omission, in order to punish people who were fraudulent, or at least if fraud is involved, it should not be condoned. And so in this situation, with the facts that we have, and this is not a complex case, the way that this was discovered is the taxing units simply took the information that Kinder Morgan had either sworn to, attested to, or filed with a federal or state government agency, or in its investor information, or SEC, and plugged it into the comptroller's formula. There was a huge variance that was recognized. So somebody is not getting the full story. And that is what brought all of this about. So when counsel was engaged, and this occurred in 2014, as we have in exhibit number 2, the Kindle letter put Kinder Morgan on notice, and Kinder Morgan responded by saying, we're not going to meet with you, you have to go through the tax code. But in 2014, this is when it occurred. I was not engaged until the end of 2017, 3 years later. So there's this recurring assertion of tax ferret, which has absolutely no legitimate basis whatsoever. The properties, as I've noted, these properties were billed. These properties have been identified. The argument is
just so I understand that, I mean, the code doesn't use the term tax ferret, right? So does it really matter whether this fits within the traditional definition of a tax ferret or not? All we need to know is it authorized by 6.30 or some other portion of the tax code, right?
That is our position, and that's what I've argued in my brief. The issue is that it has been a recurring assertion by Kinder Morgan when Kinder Morgan knew that none of the elements even existed. And so I am in agreement that this is a question of should a school, a hospital, a county, should they be able to pursue tax fraud under 6.30 or under the tax code or the education code? And the answer, I believe, is yes, because this court does not want to reward fraudulent behavior. And Kinder Morgan received these bills. Kinder Morgan knows which properties these are at issue. And Kinder Morgan, when they made their payment, knew that the fraud had occurred.
And to be clear, you think the taxing unit should be able to pursue tax fraud even if the appraisal district has found that there was none?
We do believe that that is the case. And this, it's a very bizarre position that we think the appraisal district has taken in this case to actually carry the water for Kinder Morgan. At most, we would expect the appraisal district to be neutral and to, observe or cooperate. We certainly have the case in Scurry County, and there is a new chief appraiser. Since the new chief appraiser has come, the lawyers for the appraisal district have taken this definite neutral stance in that. And it is unusual that the appraisal district, who is a poor area, why are they spending, I think what the brief said, $100,000 to defend Kinder Morgan is unknown to me. But
I took it that they were making an argument that your position will have collateral consequences for the administration of the tax code. So it's not, I'm not sure if you're making some insinuation about them, but that's the way that I understood it. Is there anything to the argument that if we read delinquent the way that you're describing, it will have consequences for how that word is used in other provisions of the tax code by appraisal districts and other entities that are affected?
I do not believe that it will be a floodgate of issues and assertions. Instead, we believe that the court should limit it to a situation where fraud has been alleged, because that is what the situation that we believe exists in this case, in that the taxpayer got a bill, knew that it was not at the right amount, and therefore those property taxes which are not paid should be considered delinquent. They should have been paid when they got the bill. And trying to live on a technicality that, well, the bill wasn't sent out because we were successful in our fraud. It didn't say the exact amount that we were successful in defrauding you.
Is this not an argument that could have substantial consequences for much more ordinary taxpayers?
I do not believe so. We've got the TCPA, which has been asserted by the defendants, and if there's not a good case and strong evidence to support actual fraud, then I don't think that any of those would be pursued. Now, if there is an individual homeowner or someone else who is engaged in significant fraud, then I think they should be held responsible. If that's what the Constitution says. You have to pay the taxes. And it also, all of this goes back to equal and uniform. If there is tax fraud, there is not equal and uniform. And what we presented to the ARB was a showing of the three major oil companies in Pecos County, and how the valuations, there was a variance even in the valuations there. And what happens if you have tax fraud is you do not have equal and uniform, and you do not have the payment of the taxes that are in fact due. We also have the fact that the tax code allows a school district or a taxing unit to pursue their claims as a challenge, and that is exactly what we did. This argument that there would be there's some appraisal on a contingency, that doesn't apply because of the mechanism set out in the tax code, which is it's presented to a jury, and a jury determines the values, and then the judge enters an order on the value, on the accurate value, and that is the number that applies. So we also have it under the tax code, and we've also mentioned in our brief that we have the education code, which is very clear, and there's not really even much response from the petitioners with regard to the language there. It says that a school district can engage someone to collect taxes. And that's what doesn't say delinquent, doesn't say past due. And that's what that's what was involved relative to employing my legal services and entering the contract.
Are there any other questions? Thank you, Mr. Lemon.
Thank you.
Mr. Heidler, I believe you have 5 minutes for rebuttal.
Thank you, Your Honor. May it please the court. The taxing unit contends that Kinder Morgan has committed taxpayer fraud, but I'd like to point out the trial court heard that evidence and rejected that contention in its findings of fact. The record here is clear. The taxing unit did not bring this fraud claim based on some hot tip that Kinder Morgan had committed fraud. The taxing unit brought this claim after an out-of-state company, U.S. Consults, came into Texas and approached the taxing unit with this proposal for increasing tax revenues by bringing these appraisal challenges. But there was just one problem. Under Texas law, the only way that a taxing unit can challenge the value of an individual taxpayer's property under the case law is by alleging and proving that the taxpayer defrauded the appraisal district, resulting in an appraisal that's too low. So that's the only reason they're alleging fraud here. They have to do it. It's the only type of claim they would have available. Now, Justice Busby, you asked about Willacy County and Section 3101G of the tax code, which refer to failure to send or receive a tax bill not affecting the due date or the delinquency date. But Willacy and 3101G are both talking about a situation where taxes have been imposed. Okay, so the taxpayer could go to the records and see that the taxes have been imposed, and then for some clerical reason, the tax bill is not sent or received. These additional taxes that the taxing unit is referring to in this case have not even been imposed on Kinder Morgan. Okay, so this is not a situation that would fall under 3101G of the tax code.
Why should all these issues be litigated on a motion to show authority under Rule 12?
So you asked the question whether the motion to show authority would be premature. It is not, because again, these taxes have never been imposed. And because the taxes have never been imposed, they cannot be due. And because they cannot be due, they cannot be delinquent. Section 6.30.
Can they be collected?
No, Your Honor, they cannot be.
Education code?
No, Your Honor, they cannot be collected. They've never been assessed. They've never been imposed, and they've never been sent out on a tax bill. So these are not collectible taxes.
But what if eventually it would result in collection? What's going on here? Then isn't that enough?
Your Honor, it's not.
If they're successful, it would result in collection, right?
That is correct, but it's irrelevant whether they would have authority to engage Mr. Lemon on a contingent fee contract to bring a delinquent tax suit if we ever got to that phase. Right now, this is an appeal from a taxing unit challenge in the Appraisal Review Board to an appraisal. And
well, right now it's an appeal from a grant of a motion to show authority.
Yes, Your Honor, that motion to show authority was filed in an appeal to the district court from the ARB's ruling on this taxing unit challenge. And so the question for the motion to show authority is whether the taxing unit has authority to engage Mr. Lemon on a contingent fee basis to bring this taxing unit challenge and to bring the appeal to the courts from the taxing unit challenge. And there is no provision.
If we agree with you on that, do you agree that under SACROC we would still have to remand and say that it should not have been dismissed with prejudice so that the school district has the opportunity to retain additional counsel?
No, Your Honor, the school district had an opportunity to retain additional counsel. When we filed the Rule 12 motion, they filed a response. They could have said, we know that that Kinder Morgan and the appraisal district are asking the court to strike the pleadings. Don't do that, because at the very least, we want to bring in additional counsel.
So they have to lay down basically and agree with you and say, well, we're going to go ahead and bring in additional counsel. Otherwise, they've forfeited any opportunity to cure the problem.
No, Your Honor, but they have to inform the trial court that they want to bring in additional counsel when we get to the hearing. And we go to look at the end of the hearing, the trial court says, I rule in your favor. Okay, he's granting the Rule 12 motion. Even then, the taxing unit didn't step up and say, hold on, we want to bring in additional counsel. In fact, they've never told the trial court at all that they want to bring in additional counsel. So in a case like this, where they never inform the trial court that they need an opportunity to bring in additional counsel, Rule 12 does not require the trial court to give them some arbitrary amount of time. He said the trial court didn't come forward to the taxing unit and say, hey, do you want to bring in additional counsel? That's not the trial court's responsibility. And the trial court has discretion to dismiss the case in a situation like that. Justice Young, you asked about collateral consequences. Let me be clear about this. If the Court of Appeals decision is not corrected, the risk here is the creation of a litigation cottage industry in which taxing units across Texas will use the Court of Appeals opinion as authority to bring these contingent fee challenges to appraisal values of especially valuable real property like the oil and gas interests here. And the potential threat to the oil and gas industry has prompted Texoga to weigh in, but the threat goes far beyond oil and gas interests. It would extend to commercial real estate, industrial facilities, and any particularly valuable real property. So to ensure that property appraisals in Texas remain equal and uniform as the Constitution requires, we ask the court to hold that Texas law does not authorize a taxing unit to hire a contingent fee attorney to bring these appraisal challenges. Thank you.
Any other questions? Thank you, Mr. Heidler. Thank you, counsel. The case is submitted. That concludes the arguments we have set for today.